In this series of information technology, which is part of cyber law already, we have discussed four number of questions, and question number 5 that we would like to discuss in this lecture is what penalty is provided for damage to computer system or computer network. So the very answer to this particular question we would discuss certain provisions of Information Technology Act of 2000. So in particularly section 2565 of the act provide regarding tampering with computer source documents. So the very expression computer source means the listing of programs, computer commands, design and layout, and program analysis of computer resource in any form. So the very tampering here means who intentionally conceals, destroys, or alters, or intentionally or knowingly causes another to cancel, destroy, or alter any computer source code used for a computer or computer program or computer system or computer network when such computer code is required to be kept or maintained by law for the time being enforced shall be punishable with imprisonment up to 3 years or with fine which may extend up to Rs 2 lakh or with both. And now we would like to discuss section 66A and also of 66B and 66C, 66D and 66E and 66F, which were inserted under the very amendment of 2008 of the Information Technology Act of 2000 and which came into effect in 2009. So, in particularly, it deals with hacking with computer system, and that particularly wherever with the intent to cause or knowing that is likely to cause wrongful loss or damage to the public or any person destroys or deletes or alters any information residing in a computer resource or diminishes its value or utility or affects it injuriously by any means commits hacking. Further, whoever commits hacking shall be punished with imprisonment up to 3 years or with fine which may extend to Rs 5 lakh or with both. So, also receiving stolen computer or communication device using another's password as provided under section 66B and section 66C and also section 66D, which deals with cheating computer resources, and section 66E relating to publishing private images, and section 66M, which deals with acts of cyber terrorism, and in all these cases, whoever commits hacking shall be punished with imprisonment up to 3 years or with fine which may extend to Rs 5 lakh or with both. And now we would like to discuss the provisions of section 67 of the Act, and that relates to publishing of information which is obscene in electronic form. So, any person who publishes or transmits or causes to be published in the electronic form any material which is appeals to the interest of, and if it is effect in such as to corrupt persons who are likely to read, see, or hear the matter shall be punished on first conviction with imprisonment of either description for a term which may extend to 5 years or with fine which may extend to arrest 10 lakh in the event of a second or subsequent conviction. The imprisonment may extend to 10 years and the fine may extend to arrest 10 lakh. So, Section 67A, which also falls under Section 67 in regards to the very penalty of imprisonment and fine that relates to publishing sexual acts, and Section 67C relates to failure to maintain records. So, these two sections, as Section 67A and Section 67C, were inserted under the amendment of 2008 of the Information Technology Act. And now we would like to discuss the provisions of Section 68, which deals with refusal to comply with orders. So, or to any directions, the controller may, by order, direct a certifying authority or any employee of such authority to take such measures or cease carrying on such activities as specified in the order if those are necessary to ensure compliance with the provisions of the Act. Those rules which are enacted in 2011 as information technology rules and those rules of 2021 and also the rules of 2023, any regulations made thereunder, any person who fails to comply with any such order shall be guilty of an offense and shall be liable on conviction to imprisonment for a term not exceeding 2 years or to a fine not exceeding as 1 lakh or both. So, these provisions as per the rules enacted in 2011, 2021 and 2023 regarding Information Technology Amendment Act of 2008. So now we would like to discuss the provisions relating to Section 69, which relates to refusal to disrupt data. So, if the controller is satisfied that it is necessary or expedient, so to do in interest of the sovereignty or integrity of India, the security of the state-friendly relations with foreign states or public order or preventing incitement to the commission of any cognizable offense for reason to be recorded in writing by order, direct any agency of the government to intercept any information transmitted through any computer resource. In such a case, the subscriber or any person in charge of the computer resource shall extend all facilities and technical assistance to describe the information. If fails to provide the necessary assistance, then he shall be punished with an imprisonment for a term which may extend to 7 years. And now we would like to discuss another important provision relating to Information Technology Act, and that is Section 70 regarding access to protected system. The appropriate government may declare that any computer system or computer network to be a protected system. It may authorize persons to have access to the protected system. Any person who secures access or attempts to secure access to a protected system without authority from the appropriate government shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. And the other provision relating to misrepresentation as provided under section 71, so the very penalty for misrepresentation or suppresses any material fact from the controller or the certifying authority for obtaining any license or digital signature certificate shall be punished with imprisonment for a term which may extend to 2 years or with fine which may extend to Rs 1 lakh or with both. And now we would like to discuss the penalty regarding breach of privacy as provided under section 72 of the I.T.Act of 2000. So also section 72A for regarding breach of lawful contract. So, any person empowered under the Act who has secured access to any electronic record, book, register, correspondence, information, document, or other material, and he without the consent of the person concerned discloses the same to any other person shall be punished with imprisonment for a term which may extend to 2 years or with fine which may extend to Rs 1 lakh or with both as per the provisions of section 72 and section 72A in regards to breach of privacy and breach of lawful contract, and in particularly section 72A was inserted under the Information Technology Amendment Act of 2008, which came into effect in 2009. And now we would discuss regarding penalty for publishing digital signature certificate falls in particulars, those mentioned under such digital signature certificates publication. So, it falls under section 73 of the Information Technology Act. So, no person shall publish a digital signature certificate or otherwise make it available to any other person with the knowledge that the certifying authority listed in the certificate has not issued it. The subscriber listed in the certificate has not accepted it, or the certificate has been revoked or suspended unless such publication is for the purpose of verifying a digital signature created prior as such suspension or revocation. So, in all these cases, as the penalty provided for publishing digital signature certificate falls in certain particulars as per the provisions of section 73, the imprisonment is up to 2 years and the fine is up to 1 lakh rupees or with both. And now we would like to discuss the provisions of section 74 of the I.T. Act relating to publishing for fraudulent purpose as provided under section 74. whoever knowingly creates, publishes, or otherwise make available a digital signature certificate for any fraudulent or unlawful purpose shall be punished with imprisonment for a term which may extend to 2 years, or with fine which may extend to Rs 1 lakh, or with both. And Section 75 of the Act relates to those offences committed outside India. So, Section 75 of the Act applies for offences or contraventions committed outside India. The very provisions of this Act and those rules made thereunder in 2011 and 2021 and also in 2023 shall apply also to any offence or contravention committed outside India by any person, irrespective of his nationality. For this application, it is necessary that the act or conduct constituting the offence or contravention involves a computer system, or computer network located in India. And now, finally, we would like to discuss the provisions of Section 76 of the I.T.Act of 2000 relating to penalty, and that particular penalty and provision relates to confiscation. So, any computer system, the floppies, compact disc, tape drives, or any other accessories related thereto, in respect of which provision of this Act, rules, or regulations made thereunder in 2011 and 2022, and finally those rules made thereunder in 2023, has been or being contravened or committed any such confiscation shall be liable to be confiscation as provided under Section 76 of the Act, and the very penalties and conviction not to interfere with other punishment. So, no penalty imposed or conviction made under this Act shall prevent the imposition of any other punishment to which the person affected thereby is liable under any other law for the time being in force. So also, the Act deals with the power to investigate offences as provided under Section 78 of the Information Technology Act, and also the rules made thereunder in 2011, 2022, and finally those rules made thereunder in 2023. So, notwithstanding anything contained in the Code of Criminal Procedure, a police officer not below the rank of Deputy Superintendent of Police shall investigate any offence committed or any contravention committed in the Act, and shall investigate such offences as provided under Section 78 of the Information Technology Act. So, all these provisions starting from Section 65 to Section 78 of the Information Technology Act, which was amended in 2008 and came into effect in 2009. And those rules made thereunder as per the rules of 2011, rules of 2021, and finally those rules made thereunder in 2023. They finally provides all kinds of penalties would be imposed either for tampering with computer source or documents as provided under section 65, also hacking with computer system as provided under section 66 of the I.T.Act, also receiving stolen computer or communication device and using another's password, cheating computer resource, or publishing any private images, and all acts of cyber terrorism. Besides all these provisions as per Section 66A to 66F as inserted under the Amendment Act of 2008, so also the provisions relating to publishing obscene materials in a computer system and also publishing sexual acts and failure to maintain records as provided under section 67 and 67A and C, which were inserted under the Amendment Act of 2008, so also refusal to comply with orders of the controller and the certifying authorities and refusal to decrypt data, access to protected system. So also penalty would be imposed for misrepresentation and for breach of privacy and for breach of any lawful contract as provided under section 68 to section 72A and particularly section 72A, which was inserted under the amendment of 2008. Besides all these above, penalty could be imposed for publishing false electronic signature certificate or publishing for fraudulent purpose from a computer system or a computer program. And also, finally, the offenses committed outside India in contravention to the provisions of the Information Technology Act of 2000 and which was amended in 2008, and those rules made thereunder either in 2011, 2021, and finally in 2023. And finally, the penalty for confiscation and those penalties besides the very power for investigating offences, which also finally provided under section 78 of the Act and as per the provisions of section 78 of the Information Technology Act, the very power to investigate all those offences committed in contravention to the provisions of the Information Technology Act, the very officer who do investigation of such offences shall be a police officer not below the rank of deputy superintendent of police as provided under the Information Technology Act of 2000. So, in this particular answer, we have completely dealt with all the penalties as provided relating to damage to any computer or any computer system or computer network. as provided from Section 65 to Section 78 of the I.T.Act, including those amendments of 2008 which came into effect in 2009. So also, those offences committed in contravention to the provisions of the rules made thereunder in 2011, 2021, and finally those rules made thereunder in 2023.